Hello, and welcome to the 8th of my series on the Consumer Bankruptcy Reform Act of 2020. I'm Dave Giddens with the law firm of Giddens & Gatton, PC in Albuquerque, New Mexico. My firm practices primarily in the areas of bankruptcy and creditors' rights throughout the state of New Mexico. In my previous program, we took a look at the restructuring plans for home loans and other types of secured debts. Today, we will look at the Chapter 10 plan for dealing with unsecured and priority claims. If the debtor has a minimum payment obligation, the debtor is required to propose a repayment plan under which the debtor must pay at least that minimum payment over 3 years. It can be paid under any combination of future income, non-exempt or exempt assets. There is no requirement that priority claims, such as taxes, be paid in full. The only requirement is paying the minimum payment obligation. The protection for creditors is that they can seek to have the case dismissed for a manifestly improper use of the bankruptcy system. If the plan proposes to pay the minimum payment obligation, is feasible, is not proposed in bad faith, covers court fees, and the debtor is current on post-bankruptcy domestic support obligations, the court is required to confirm the plan. If there is no objection to the plan, no confirmation hearing is required. Upon confirmation, rather than at the conclusion of payments, the debtor receives a discharge, which is also one of the 10 major changes proposed in the CBRA. A debtor can only receive a discharge under Chapter 10 every 6 years. The obligations under the plan are enforceable only by the trustee, and the obligations are secured by a lien on all the debtor's non-exempt assets. If the debtor defaults, the discharge remains in effect, and the trustee will liquidate the non-exempt assets. Since my last broadcast, I could find no new activity on the legislative front relating to consumer bankruptcy reform. Of interest to those of us in the industry, there were 106,958 new bankruptcy filings in the first quarter of 2021. Which was down from the 177,245 filings during the same period in 2020. However, the month of March 2021 saw 43,425 new filings, which is an increase of 41% over the month of February. This may be a sign that the vaccine rollout and the economic recovery will accelerate the return to pre-pandemic bankruptcy filing levels. Stay tuned. Next time, we will look at proposed changes to payment of attorney's fees and how that will make it easier for consumers to file. I'll also be on the lookout for any new developments in the legislative arena. Until next time, stay safe and have a great day.